No, they do not. Most federal criminal cases result in a guilty plea of some sort, but there are exceptions to that, and some cases do go to trial for good reason. Sometimes errors were made by law enforcement. There may be affirmative defenses to the charges that were brought against you, or you simply didn't do what you're accused of doing. If those situations arise, then those cases should go to trial, and they do go to trial most of the time if the person is represented by an experienced criminal defense attorney. But most cases that are brought typically result in a guilty plea, either because the person charged actually committed the crime for which they were charged or some lesser offense, or because the evidence of guilt is clear or perhaps even overwhelming, and there was nothing to be gained by trying to defend against those charges because of the overwhelming evidence of guilt. And a better course is to try to negotiate a plea to a lesser offense or to less jail time. So there are reasons why they plead that make good sense. So, but yes, the vast majority of those cases will end up resulting in a plea unless the person charged did not commit the crime, or there are affirmative defenses available to you that would absolve you from guilt for the offense charged, or because the penalties are so severe that if you plead, it's effectively a life sentence, so you might as well hold them to their burden of proof to determine if in fact you're guilty or not. So a lot of those factors come into play, but for the most part, there will typically be a plea at some point in most federal cases.